Hello everybody, I'm George from Ireland, so welcome back to the English Law channel. And yes, I changed my clothes just slightly, partly so you can tell the videos apart and so can I at a glance. Anyway, so I'm carrying on with leases. Landlord and tenant, it's the sort of bread and butter of a high street solicitor's life. So looking into how leases are created, there are legal leases first of all. So a legal lease can exist at law as opposed to in equity, as per section 1.1b of the Law Property Act 1925. So it can be legal, it has to conform to certain formal requirements. So the length of the lease is vital. Bear in mind that even though it must have a length of a lease, it's also got to fulfill the requirements of a lease. Certain leases are exempt from these formality requirements as per sections 52D and 54.2 of the LPA 1925. Now, these exceptions are only applicable where three requirements are fulfilled. First of all, the lease cannot be granted for a term of 3 years or less than that, and that could include a periodic lease based on the payment of rent. Second of all, the lease must take effect in possession. That means the term cannot commence as the same day that the lease is granted. So very often there's a delay of at least 1 day. And lastly, the lease must be granted at the usual market rate, and that's as per Fitz-Kristen LLP against Panayi 2008. So it can't be exorbitantly high or ridiculously low. It doesn't have to be an exact figure. So leases of more than of over 3 years, up to and including 7 years, can only be created by deed. That's as per the Law Property Act 1925 or the Law Property Miscellaneous Provisions Act 1989, and they spell out what a deed is. A lease of more than 7 years is now a triggering event for registration and pursuant to the Land Registration Act 2002, that's section 27. And more than that, the creation by deed must be registered to take effect in law. So let's look at leases which oblige you to register them substantively. Any legal leasehold estate for a term of over 7 years means that you need to register it as per section 3.3 of the Land Registration Act 2002. So the length of the lease, which means you must register it, has been reduced a lot. It used to be 21 years under the Law Property Act 1925, now it's only 7 years. So a lease of over 7 years will require its own proper entry in the land registry. So remember, they're trying to get more and more land to be registered. About 90% of land in England and Wales already is registered. It's going to be 100% eventually, but some people are never going to sell, are never going to rent it out. It's going to be very close to 100%, and then obviously the next logical step is to say, well, you simply have to register everything within a certain deadline. So how about leases protected by notices and leases that override? A lease of more than 3 years, but under 7 years, can be protected by entry. If you put it on the notice of entry of notice, if you put it on the charges register of registered title, that's as per section 32 of the Land Registration Act 2002. A lease of 3 years or less than that cannot be entered on the register. So the objective of that is not to clog up the register with lots of sixpenny matters. So although leases are more than 3 years, but under 7 years, can be protected by entry of notice, there's not much reason to do so. They are automatically overriding interests as per paragraph 1, schedule 3 of the Land Registration Act 2002. The reason why you can't protect the lease for 3 years is, as I say, because they don't want to have to bother with lots of very short leases. It'd be annoying. A lease of 1 month or something like that, a holiday let. So leases created prior to October 2003 would have been overriding interests as by the Land Registration Act 1925, and they're still overriding, okay, as per section 12, paragraph 12 of the Land Registration Act 2002. Well, how about equitable leases? When one tries to create a legal lease, but you haven't conformed to the requirements that I mentioned here and before, then it becomes an equitable lease. For this to work, the agreement must fulfill the requirements for a estate contract as per section 2 of the Law Property Miscellaneous Provisions Act 1989. And that, remember, that supplants the Law Property Act 1925 in this matter. So if the requirements are fulfilled, then the principle in Walsh and Lonsdale is applicable, that well-known 1882 case. All right, so then an issue which people often broach is the extent to which an agreement for a lease is valid as a lease. Between parties it might be, but in some ways it's not. The doctrine, it really turns on this, the discretionary remedy of specific performance. The court will say, no, you actually have to, you must do what you said you would do. So regard the situation where a remedy is not there. For example, Coatsworth and Johnson, a case from 1886, and it wasn't decided until 1890. Prior to 1926, an equitable lease, which is a form of estate contract, could be obliterated by a bona fide purchase of legal estate for value without notice. Remember, that's equity's darling. But the situation after the 1925 agreements is different, because it regards unregistered land as per the Land Charges Act 1972, where registrable as Class C4 land charges. So the land is registrable. Equitable leases can and usually are protected by entry on the land register, and they are regarded as an overriding interest if they come under the terms of protection set out in paragraph 2 of Schedule 3 of the Land Registration Act 2002. So let's look at determination of leases, and this is to bring them to a close early usually. There's forfeiture. A lease determined lease or tenancy can be brought to an end prematurely in a number of different ways. These usually are very straightforward, but there are some issues about forfeiture and notice which are worth discussing. So the Law Commission often has said that there should be some major reform in this area, but it hasn't happened so far. Forfeiture is when the landlord says he wants to come back into the property, the house, or even just the land, the field, because the tenant has broken the covenant. Bear in mind there are special controls in forfeiture of residential tenancies. Your landlord can't just barge in through the door every day. So a lease cannot be forfeited for breach of covenant unless there's something about a forfeiture clause in that covenant, and the landlord might be prevented from going ahead with forfeiture if he waives the breach. He knows about it but chooses to do nothing about it for ages. There's some sort of act which is indubitable, suggesting that he was willing to tolerate the situation. Matthews and Smallwood, 1910. He can't know there's a breach of it and just put up with it for ages and suddenly decide it's a huge problem. No, you accepted it. Okay, so other things to think about. So the right of forfeiture can be enforced. You could issue and serve a writ for possession. However, there are certain conditions that have to be fulfilled. Because there's a breach of covenant to pay rent. That's different from a breach of another minor covenant, like not to do something noisome. How about non-payment of rent? You have to formally demand the rent, unless this is ruled out by the lease or dispensed with by the Common Law Procedure Act 1852. The tenant could also apply for relief in equity. So let me give you more time. There are other breaches which would mean that the landlord takes action. There's a statutory notice in writing as pursuant to the Law Property Act 1925, and it'll set out what the breach was, not just a breach, you have to say which one, and oblige the tenant to put it right. The tenant might have to pay compensation, but if the breach can be put right, then it should be remedied, and the landlord must permit the tenant to allow a reasonable period of time, in view of whatever the breach was, to set matters right. And anyway, they can then go ahead and enforce the forfeiture, and if they're successful, the forfeiture will also impact any subtenant because the lease will be nullified. Remember, the tenant could rent something out again to a subtenant below him. The tenant might not actually be on the land. The issue here is whether the breach is something which can be remedied, and that is vital in deciding whether a Section 146 notice doesn't require the breach to be remedied or not. We have to think about whether the tenant has had enough time to comply with the notice or not. So how about relief against forfeiture? So any time before the landlord has come back into the property, the tenant may seek relief against forfeiture, and this can be given to him in a way that the court thinks fair, as per the Law Property Act 1925. The subtenant can also seek relief under that same act. So could the holder of a charge on the land. For example, Bland against Ingram's Estate Limited, 2001. A tenant can seek relief if the landlord has forfeited the lease by coming back onto the land. Bilson and Residential Appointments Limited, 1992. So a crucial matter here is whether the forfeiture is an excessive penalty, bearing in mind the nature of the breach. It might have been a trifling breach. And if it is an overreaction, then relief is probably going to be granted to the tenant. So court can give relief if the breach cannot be remedied. So think of the sort of matters that the court will have to consider in such an issue to decide whether to grant relief or not. Shiloh Spinners Limited against Harding 1976 is a case. The Earl of Bathurst against Fine 1974. Central Estates Belgravia Limited against Woolger No. 2 1972. Or GMS Syndicate Limited against Gary Elliott Limited 1982. Blandon Ingram's Estate 2001, which I mentioned a while ago. Or Fryfield against West Kensington Court Limited 2015. So, about leases of more than 21 years. Sections 168, 169 of the Commonhold and Leasehold Reform Act 2002. They forfended the landlord from issuing the Section 146 notice unless the tenant has either confessed that he has committed the breach or the Leasehold Evaluation Tribunal has accepted that yes, that the breach was committed. So those sections, they came into effect in February 2005, and they have no impact on notices prior to 2005. So let's think about notice. So a fixed term lease cannot be determined by notice unless it's agreed to. That's actually there in black and white in the agreement. A periodic tenancy is determined by notice, and any term that seeks to forfend the landlord from determining the tenancy is a nullity at law, because, of course, that completely goes against what a tenancy is about. Centreploy Limited against Matlodge Limited, 1974. So there might be a contrary agreement about the notice of determination is the full period expiring at the end of a completed term, though usually 6 months in the case of a yearly tenancy. For instance, supposing there's a weekly tenancy on Monday, it can be determined by notice on or before one Monday to expire at midnight the following Sunday, giving you a week. So, subject to these provisos that I've mentioned, the lease can be terminated by either party if they give notice they want to bring the lease to an end. But the notice must be crystal clear and about what term they're availing themselves of. Aylward against Fawaz 1997. The obligations of a lease about notice and how it must be given they have to be adhered to strictly. But a bare majority of the House of Lords in Manai Investments Company against Eagle Star Life Assurance Company 1997 found that trifling breaches are not sufficient to invalidate notice, so long as the decision to terminate the lease has been declared unequivocally to the other party. There's a Ravenseth Properties against Hall 2001, a case about that. So there are other ways you can terminate a lease, but I think that's enough for this video. Toodaloo.